Welcome back, everybody, to the Florida Appellate Review. My name is Andrew Harris. I am here with Jeff Adelman and Jen Dinetz. Thanks for joining us today. I want to just briefly mention some congratulations in order for both of my co-hosts today. Jeff Adelman was recently appointed or elected as the treasurer of the Florida ABOTA, so the statewide ABOTA. Congratulations to you, Jeff, where you'll be, I think, president in 2023. And
2023.
So congratulations. And Jen recently had an amazing result with her partners, a $4.98 million verdict, I believe, if I'm right down to the dollar.
You're not a penny shy.
Not a penny shy, a cervical disc replacement case on behalf of such a deserving client. So congratulations, Jen, to you. I know we will have a future podcast, a future webinar, so you can tell everybody, all of our listeners, about your fabulous result. We're all just tickled to death.
Great result.
For your success there. So congratulations.
Thank you very much.
I will, you're welcome. I will turn it over to you, Jeff, for our first, or actually two different cases you're going to cover for everybody on some Daubert issues. Take it away, Jeff.
All right. Thank you, Andrew. Well, both of these cases involve the United Auto people. United Auto versus Progressive Rehabilitation and Orthopedic Service as assignee of Yacel Alonzo. Both of these cases have the same plaintiff's attorney. Actually, they both have the same appellant lawyer, and they're both appealed orders of County Judge Lawrence King of Miami. Now, what happened in the first one, which is United Auto versus Progressive Rehab, the second one is United Auto versus Central Therapy Center, is there was a motion for summary judgment brought by the plaintiff. And the opposing memo in opposition from United Auto, the affidavit was from the adjuster. And the adjuster laid out her experience dealing with CPT codes, dealing with claims for over 10 years. And surprisingly, quite frankly, the judge felt that this was insufficient, and he granted summary judgment, entered a final order for $1,275.26. Now, we all know when you're dealing with PIP, that's not what you're going for. The attorney's fees are massive on these cases. So in any event, the affidavit was held insufficient, and on appeal, the appellate court held that it was reversible error, and it should have been considered that it did pass the Daubert test. And if you need a refresher on Daubert, just going through here real quick, it lays it out in the opinion, section 90.702, which codifies Daubert. If scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence. I think that's the key phrase right there. Or in determining a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if, one, the testimony is based upon sufficient facts or data, two, the testimony is the product of reliable principles and methods, and three, the witness has applied the principles and methods reliably to the facts of the case. Nothing in the rule prohibits expert opinion testimony based on experience. That's a quote from Judge Lindsay on that case. So basically, they went through Daubert. It was not. First of all, they didn't have a Daubert hearing. But I think the judges were kind of telling what they were going to do in this case if there was a Daubert hearing. But the judge did not allow this to be held as sufficient for opposing summary judgment, and the panel disagreed. Now, what's interesting is on the second case, United Auto versus Central Therapy, the progressive rehab case was decided July 21st. This one was July 28th. So a week later, you have Judge Gordo writing the opinion. He's the only judge who was the same as for the other opinion here, but it was a similar circumstance where the United Auto adjuster gave an affidavit opposing the summary judgment based on the experience of the adjuster. And in addition to that, there was a doctor who gave an opinion by affidavit that he'd reviewed all of the records and he felt that it was the charges were unreasonable. And the judge again granted summary judgment on behalf of the plaintiff. And again, the judge was reversed. Now, what's interesting here, Andrew, is these are both cases in county court, but they were heard by the appellate court. Can you explain why a circuit court did not hear these type of challenges?
Sure. The legislature in 2020 amended the statute and provided that most county court cases now automatically go up to the district courts of appeal. So, and that took effect as of January 1, 2021. And so these cases were initially appealed to the circuit court, which was the prior to 2021. But because of the statutory change, that's why the cases were then transferred from the circuit court as an appellate court up to the third district court of appeal in its appellate capacity. So most county court cases now will go directly to the district courts of appeal. So that's why they were here on direct appeal in the third district.
Yeah, it's an interesting point because that's pretty significant change to be seeing these type of county court cases going directly to the for appellate review.
And one of the meaningful things there, the Florida Supreme Court a few years ago had to address whether a lot of circuit courts across the state, or some of them, only have one judge who sits in an appellate capacity. And there was a challenge to that. And the Florida Supreme Court held it was not unconstitutional or violative of any due process to only have one circuit court judge as an appellate judge. And so now, with most cases going directly from county court to the district court of appeal, which of course are always 3-judge panels, it removes that possibility. Circuit courts, for cost reasons, judicial economy, it just was not as feasible for them to assign 3 judges to every single case, which, so it has created a lot more work for the district courts of appeal here in 2021, because thousands of cases from the circuit courts across the state were transferred from county court, from the circuit court in its appellate capacity to the DCA. But nonetheless, I think it's, it ensures probably it'll bring more consistency to the law, right? Because this decision, or the 2 cases that you see here, if they were issued by the circuit court in its appellate capacity a year ago, they wouldn't be binding on any district court of appeal or precedent anywhere, or on trial judges anywhere outside of the particular circuit. And so I think, you see these decisions that Jeff, I think both of these decisions are, I know they're PIP cases, but they have relevance to everybody in civil practice. I think I look at this from my perspective, 2 different areas of the law. Treating physicians are often met with dauber challenges, right? Where defendants say that plaintiffs treating physicians don't have the qualifications, the experience to opine that treatment is reasonable and necessary. And I think these decisions would be helpful there. The other thing we see out there, the billing code experts, or I would, where defendants bring in experts who opine that the plaintiff's charges are not reasonable and necessary. Now, these cases do talk about experience alone is sufficient, but that doesn't mean that any experience alone. I think in these cases, it was the particular experience. The adjuster in both cases, right, had the specific knowledge to be able to opine on the reasonableness or lack thereof of the charges. And then in your second case, the doctor, just like treating physicians, they can review medical records and opine that treatment is reasonable and related. Well, in this case, United's doctor was sufficiently qualified based on his experience to opine that the charges were not reasonable and necessary. I think he opined there was 4 to 6 weeks of treatment, but at that point, the treatment was no longer reasonably related. So I think these cases, certainly, I think they provide a good summary of Daubert case law. There's different areas of Daubert, obviously. This just touched on a few of them, but
I feel like the judge was slightly instructing and teaching the county court attorneys.
Yes, yes. So anything else on those cases, Jeff?
Well, I just thought it was a little bit amusing in the United Auto versus Progressive Rehab case. Trial court cited several cases in support of its legal conclusion that Ms. Johnson's affidavit was insufficient. And they distinguished why this, what's up would be insufficient. And the court held that an affidavit was legally insufficient pursuant to 1.510E, where they opined that a leaky roof was caused by a storm, but inspection of the roof occurred a year after the damaged roof had been replaced. That's the Gonzalez case, 273 Southern 3rd at 1036. This court observed that unless there somehow occurred a suspension of the general laws of physics and common human experience, one cannot normally observe damages to the roof after the damaged roof was replaced. In comparison to this case, you have the entire medical record, you have the bills, it's been reviewed. So that's how they distinguish it, but I thought it was kind of a amusing comparison that they did to show something that would be insufficient.
Right, pure speculation. The other thing you mentioned, Rule 1.510, your cases, and then I know when we get to Jen's case, were all decided at the trial court level under the old summary judgment standard. And so in your two cases, in Jen's case, I know the panels noted that the appellate courts had to apply the old standard under Florida law. Now, I think me personally, I don't think that any of these decisions would have a different outcome under the new standard, but you cited to Rule 1.510E, which is slightly different now, but they were decided under the old summary judgment rule. So that's just at the appellate court level as well. The appellate court, based on the Supreme Court's instructions, had to apply the old standard. So thanks very much, Jeff, for the discussion of those Daubert cases. I will take the next case, or the case that I'm here to talk about, Adamson versus R.J. Reynolds. Now, this is an Engle progeny case. Unlike some of the recent Engle progeny cases I discussed, this does not involve closing argument. So it's a change there. It is an important case, I think, for the bar on the spoliation of evidence and adverse inference instructions. In this case, there was a defense verdict which the 4th District upheld. The plaintiff argued that the trial court had abused its discretion in giving a standard jury instruction to the jury, 301.11, on an adverse inference instruction. And so the appellate court held the trial court correctly, or was within its discretion to give the instruction. Why was there an instruction here used against the plaintiff? Now, plaintiffs often, seek adverse inference instructions or rebuttables, for spoliation, where the defendant doesn't maintain a car or doesn't maintain, a ladder, evidence which would, could arguably be critical. Well, of course, it can be used on both sides. And in this instance, it was the plaintiff who did not maintain records. And what were those records which were not maintained? Well, the decedent, she died in her early 40s. Very, very, very sad case of lung cancer. And so the issue in the Engle progeny case was whether, or one of the main issues was causation, whether the defendant's defective products, tobacco, were the cause of her lung cancer, whether she had primary or secondary lung cancer. Well, she died in the early 1990s, of course, when medical records, right? I mean, it's hard enough for a lot of us to get our medical records now, right? As attorneys, and get copies of our clients' medical records. All of us as people, right? It's not so easily accessible. Here, she died in the early 1990s. Fast forward 15 years later, the Engle decision was decided by the Supreme Court in 2006. It provided a year window for people to file lawsuits. Her husband, or she died, so her widow filed a lawsuit on her behalf. Well, retained counsel, and I'm just reading from the opinion. In an April 2008 call log, a paralegal at plaintiff's counsel's law firm memorialized a phone call with Mr. Adamson, the decedent's husband, in which the firm was, quote, trying to fill in the blanks on his discovery. The paralegal asked Mr. Adamson, quote, if he happened to have any medical records, close quote, and Mr. Adamson replied that he, quote, he shredded them all over 2 years ago because they were so old and he didn't think he would ever need them, close quote.
Not great.
So that was in the plaintiff's, computer system. The defendant served a discovery request. Now, notably, the plaintiff did not object on attorney-client privilege or work product here. And that was the opinion here, the Fourth District opinion hints at or discusses a strategy decision made by plaintiff's counsel to not raise that privilege. Hearsay objections could have been raised, although I think the hearsay objections probably would have been overcome. But certainly for everybody, do you need to put in those do you need to put that report into your own file? I mean, the paralegal was doing his or her job here, right? And this is what was said and put the records in, and here they were. So fast forward, the record is turned over by plaintiff's counsel voluntarily over to the defendant, and the defendant moved forward and asked for an adverse inference instruction. The late Judge Sasser issued a detailed order granting that adverse inference instruction. There was a mistrial for unrelated reasons. After Judge Sasser's obviously really, really sad death, Judge Rowe took over the case in the 15th Judicial Circuit. She agreed with Judge Sasser and granted the defendant's request for the adverse inference instruction, and it was given at trial. Now, what did the plaintiff raised various arguments at the trial level and the appellate level as to why the instruction. One, it's sort of obvious, which is in order to have an adverse inference instruction, the evidence has to be in the possession of a person, right? And in this case, the plaintiff presented a pretty persuasive argument. We don't know what these records were. I mean, it's a brief log note. Here's the husband in 2006. He takes medical records. We're unable. It's not like there was any evidence that he had about 1,200 pages and shredded 1,200 pages of medical records. So, but what the trial court held in the appellate court reason is, when a party destroys evidence, and I use the word destroys harshly, I don't mean it that harshly, but when a party has in possession evidence in here, that it's sort of, you can't then claim, well, because we don't know what was there, you can't give an adverse inference instruction. That's the entire reason for the adverse inference instruction, is that a party has in its possession records of which the moving party here, the defendant, is unable to do what? To utilize, because those medical records in theory could have been used to support the defendant's defenses that the plaintiff did not die of smoking related causes. I think that one of the defense theories was she actually had breast cancer, and that it would be so unusual for someone of her age to develop lung cancer. That was one of the defense theories. The really important issue here, I think, which is of note in everybody's cases, so the plaintiff argued that there was no duty to preserve the evidence here. Where did the duty arise? There's certainly, at the time that the husband, quote, shredded the medical records, he hadn't even filed a lawsuit yet.
That's so interesting.
Right. Well, what the appellate court, what the Fourth District held, and they cited to a Florida Supreme Court case, League of Women Voters versus Detzner, is that, and I'll just read it from here. It's on the decision. A duty, this is from the decision, a duty to preserve evidence exists in circumstances when a party should reasonably foresee litigation. But this is also from the opinion even further. Significantly, the Florida Supreme Court stated that, quote, even in the absence of a legal duty, though the spoliation of evidence results in an adverse inference against the party that discarded or destroyed the evidence. So even if there was no legal duty to preserve the evidence, there nonetheless could be an adverse inference instruction under the facts of the case against the party that discarded or destroyed the evidence. So
how long would someone be required to keep his ex-wife or his deceased wife's records? Reasonable is very difficult in that one, I would think.
Right. And, if you think about it, the opinion doesn't discuss when in 2006 the husband destroyed the records. So we don't know if it was before the Supreme Court Engle decision was in 2006. So we don't actually know if it was before or even after the opinion. And at that time, the notion that the husband, could have foreseen litigation or, in a way seems kind of far-fetched, right? But what the appellate court explained here, these are issues for the jury. The plaintiff could have raised those arguments in closing arguments to the jury. An adverse, on the list of spoliation and sanctions, an adverse inference instruction is really the least bad, if you want to say. It's not having a party's pleading stricken. It's not having a rebuttable presumption of negligence. So, the jury instruction itself, it says the jury may, but is not required to, take it into account. And so it gives a lot of flexibility. I think that's where the appellate court was coming from here. But yeah, it's a very harsh result here. I mean, it's easy enough, right? I know, Jen, you do medical malpractice, products liability, your firm. If you have somebody who gets in a car accident and they take their car and they see that a plaintiff is taken from the scene in a stretcher and the defendant takes their car and repairs it the next day, well, there you can see that there, the circumstances there where you could reasonably anticipate litigation, right? That obviously was not the facts here. Were not the facts here. So that's why I think that, the decision, on a big picture is probably going to be pretty helpful to plaintiffs in the big picture, because it's usually plaintiffs who are the ones who are seeking, not always, but it's usually plaintiffs who are the ones who are seeking, or at least in my experience, who are seeking the adverse inference instructions, where defendants, they're the ones who file the lawsuits, right? Obviously, plaintiffs are the master of their complaints. And so in that respect, I think it's a pretty, favorable decision in that sense, in being able to persuasively ask trial judges for, for the adverse inference instruction. The other element, in order to get an adverse inference instruction, you have to establish that it's material, to a party. And here, what the appellate court said is, the tobacco defendant had easily satisfied that this was evidence which was material. And again, that, sort of the plaintiff was behind the eight ball, because we don't know what the records were. Imagine these were dentist records, which were destroyed, right? Then there wouldn't be an adverse inference instruction here, right? Why would the dentist records? But unfortunately, all we had here was that log from the plaintiff's attorney's, computer system.
What a nightmare.
So just, I suspect this is not the end of this case. The plaintiff, I would presume, will move for rehearing here and, may seek Supreme Court review. And so this may not be the last we see of the case, in the appellate courts. But for now, it is certainly, it was a very harsh, sad outcome all the way around, for the plaintiff here and just the family. The husband, who was a widow at such a young age, his wife died at such a young age.
Horrible.
But anyways, that is the story of the Adamson versus R.J. Reynolds case from the 4th District, written by Judge Gross, who I clerked for.
Side note.
Who we've talked about, who I adore, and it's a well-reasoned opinion, but here we are. So, all right, I will turn it over to you, Jen, for a case discussing, I think, a hotel slip and fall,
and it's oddly straightforward, like no other premises cases where there's always gray area. So this is the Marta Judowitz versus the Pearl on 63rd Main LTD. This is coming from the 1st District. This opinion was written July 20th, 2021. In short, for the facts, is a woman and her husband were staying at a hotel. She had made it into the room, which was going past one section that had tile into a section that had carpet. The tile and the carpet are obviously different materials, also different colors. She had made it into the room, and then when she had gone to leave the room to essentially go over that same threshold the second time, she slipped because of the elevation change, if you will. And she suffered some pretty severe injuries. So she and her husband, she brought a claim against the hotel under 2 essential premises. One, saying that the hotel had a duty to warn because there was a hazardous condition, a dangerous condition that they knew or should have known of, and then therefore they had the duty to warn of at least that there's an issue there. And secondly, that they have a duty to continue the practice within the ordinary care to maintain their premises in a reasonably safe condition. The trial court heard testimony obviously went through the trial. There was some allegations here and there that maybe the plaintiff and her husband admitted that it was open and obvious. That wasn't an issue for the appellate court, but there's all these little details there to show that maybe they knew that there was a change in elevation or there wasn't, what have you. The trial court granted motion for summary judgment on behalf of the defendant, and the case was done. Just kidding. We went to the appellate court. So in the appellate court, they obviously lay down the different facts of what the plaintiff must show to prove their case, and that obviously they have the burden. They have to show that the defendant was on notice or had either actual or constructive notice of this issue, that the defendant owed a duty to protect their people, their patrons, their invitees of this dangerous condition. Then that the defendant breached their duty, that the damages that the plaintiff suffered were causally connected to the duty that was breached, and then damages resulted. So there you have torts 101. But the important facts here that I believe that the appellate court laid out is that there are two duties that are relevant here for a business owner. One is the duty to warn of concealed dangers that they knew or should have known of. And secondly, that they must maintain their premises in reasonably safe conditions. What's important with these two duties is that they are indeed separate and distinct duties. So one can have in this case, they found that there was no duty to warn. They found that the carpet versus tile, the elevation was not that different. There was very different material with there, like it was open and obvious. Sorry, you lose on that one because it is open and obvious. Just because there's change in elevation, the courts have said time and time again, that doesn't mean it's a dangerous condition on its own. However, the important distinction in this case is they found there was no duty to warn, but they did find that there was a duty to maintain your premises in a reasonably safe condition. And in fact, the hotel did not. And they did not on, I'm just going to call it a technicality. But that's how we get through these cases. So there was a administrative building code that said when you have a change in elevation that is greater, that the change there is greater than 1/4 of an inch, but smaller than 1/2 of an inch, it requires some beveling there. So something in between to kind of measure out the elevation. And in this case, there was no beveling. And there's no need for any kind of expert, any kind of person to come in and testify about the building codes or what have you necessarily. The building codes are the building codes, just like the law is the law. And if you violate the law, if you violate the building code, the courts have found that it's not prima facie evidence of negligence per se, but it is prima facie evidence of negligence. And therefore we have a genuine dispute of material fact. So the court did affirm on the duty to warn motion for summary judgment, finding that there was no duty, but they did reverse on the factor of the duty to use ordinary care to maintain your premises in a reasonably safe condition because they violated that building code. So again, technicality, but if you have it, use it. And it can be used on either side. So I think it was the right decision, obviously.
So one of my daughters is 7, and so I've been working with her on fractions. Now she's not great at it, right? But the 1/4 of an inch, of course, is 2/8 of an inch. And so the technicality, you got up to 3/8 of an inch. So literally we're talking about 1/8 of an inch made a difference here. But so my question for both of you as trial attorneys, let's imagine that there was no building code violation here. I'm sort of putting you both on the spot. What do you do there in that situation to try and show that the duty to maintain the premises in a reasonably safe condition? What options would be available?
So I think it's tough, obviously, but then you have to turn to the totality of the circumstances. Because we have similar cases. Like I have a case right now where it's in the Colony Hotel and there's stairs, but they're all black, so it's concealed. So you can't really see where the stairs are. So when you think about the circumstances there, just like in the Colony, I don't know about the Pearl on 63rd and Main. Maybe they have most of their invitees are elderly population. Maybe this was an ADA compliant room, and maybe that was not ADA compliant. So I think you'd have to look more at the specifics because you'd have to build your case that way.
Yeah, I can't agree enough with Jen with what she just said, but I would also add to that in saying I think photographic evidence is going to be huge here, because I think a jury probably going to be skeptical, and you're going to really have to explain how somebody missed it, even if, again, I mean, the code is the code, but the hypothetical is if there's no code, could this have happened to them? Now, again, I think the photo is going to be really important. I think that if this is a type of case that you're going to go to trial, and you might even want to get a forensic photographer to measure it and show the differences, but certainly not. I'm glad for the plaintiff that they're able to proceed, but I still don't think they're out of the woods. I think it sounds like a real tough sell.
Right, and obviously a jury comparative fault here, could put a high amount of comparative fault on a plaintiff here.
Yeah.
The other thing, of course, is a directed verdict as well. Now, the fact that this case was decided under the old summary judgment rule, again, as I mentioned before, but even under the new rule now, so under the new rule, the Supreme Court has explained that the standard for summary judgment motions has to be akin to the standard for directed verdicts, but that doesn't mean that just because a trial judge denies a motion for summary judgment, or should have, that you're out of the woods when it comes to a directed verdict later on. And so that's just something, in preparing a case for trial. And then ultimately, right, the jury appeal here, no pun intended, right, in saying appeal, but the jury appeal of the case here because of comparative fault. I mean, we've all seen slip and fall cases in supermarkets, and it's, it's one thing to get past summary judgment. It's another thing, to evaluate where a jury of one's peers would put this on here in terms of, especially in elevation, right? This is not a hidden danger necessarily. This is something it's open and obvious.
Aisle. Yeah. And everyone stays in hotel rooms. Everyone knows that there's tile in the bathroom and carpet in the bedroom for the most part. I think it would be very tough in front of a jury unless you had those other appealing facts.
Right. So, but I think the appellate court got the, certainly got the decision right. The technicality or not, if there had not been a building code, obviously, I mean, I think it's one of those you probably need to have an expert come in. The standard of care
on this one.
In other hotels, what the standard of care is, even in the absence of a building code, I think is pretty much were there prior, incidents? Probably not here, right? But that's always something in discovery, to send out a request, whether they had notice of a dangerous condition, maybe not if this was the first time, or if this is the first time you get a discovery, obviously, there's nothing you can do with that. But
and I meant to add, especially in this case, they found that when you violate a building code as they did, that is sufficient for actual notice. So just like it with lawyers, you cannot claim ignorance to the law as a defense. You can't do it with building codes either.
Right, and that's one of the issues, the concept of actual or constructive notice, right? In transitory substance cases, all the time, it's very hard, obviously, to prove actual notice, but the concept of constructive notice, you don't need to show constructive notice when the defendant is responsible for the actual condition. And I think sometimes people get caught up in that, so if you have evidence that an employee is the one who put the water on the ground or put the banana on the ground, that's constructive notice. You don't have to prove that it was there for a certain amount of time, 15 minutes, 18 minutes. It's the same thing here. This is a condition which was created, so that I would argue it's probably actual notice, right? But even if not actual notice that it violated the code, like you said, Jen, certainly constructive notice that you should have been on notice that it violated the building code. And so that's how the constructive notice element was able to be established here. Anything else on this case? No, looks like we're good. I want to thank you both. Like I said, it was a very exciting recent week or weeks for both of you, and just want to congratulate both of you, all the success on a professional level there. I want to thank everybody for listening here. And once again, if you all have any, if you want to come on as a guest for any of our podcasts, we are going to start doing that. It has been fun, right, doing the case law updates. We can't get to all the cases. We could have probably had like 9 different cases to choose from this week. The appellate courts have been active recently. So stay tuned for a podcast coming up in the near future. Thank you so much, everybody. Bye-bye.